The fourth fair use factor is the effect of the use upon the potential market for, or value of, the copyrighted work. This is a very complicated question. Google would no doubt argue that its library project will not harm authors, and that in fact it has the enormous potential to benefit them by stimulating demand for their books. The author and publisher plaintiffs won't necessarily dispute this, but they would argue that the digital library Google is attempting to create is effectively a new market for their works, and that their rights extend to this new market. How would a court determine if the scanning required to generate the metadata driving Google's book search engine is part of the copyright owner's market? Copyright owners have often claimed that new opportunities created by technological change are part of the intrinsic value of or potential future markets for their works. A copyright owner can't prove market effect by demonstrating that if he wins the lawsuit, the defendant and people like the defendant would have to pay him for permission. Likewise, a defendant can't prove that there is no market effect by demonstrating that if it wins the lawsuit, it will be under no obligation to pay the copyright owner, and thus there is no market effect in the first place. This kind of circular logic proves nothing for either party in either direction. The fact is, to determine whether there is a market effect, a court must essentially determine whether the use in question is something that falls within the legitimate sphere of copyright owner control or not. Courts will look at previous fair use cases to make this determination. Although the fair use doctrine is frequently characterized as unpredictable, there are actually a number of clear principles which emerge from the case law that are relevant to this analysis. First, it's clear that the rights of the copyright owner are not strictly limited by its past exploitation. In other words, just because the copyright owner has not yet ventured into a market doesn't mean that that market doesn't belong to the copyright owner. Second, when a copyright owner claims that a defendant's use will have an effect on a particular market, this effect has to appear at least somewhat likely. It certainly can't be entirely speculative. Third, the kinds of market effects that courts will recognize are limited in several important ways. The first limiting principle is simply likelihood. The market for potential derivative uses includes only those that creators of original works would in general develop or license others to develop. It's unlikely that authors will license political opponents, potential critics, or would-be parodists to use substantial parts of their works. It's also unlikely that a market for a particular use would emerge if the costs of seeking permission far outweigh the potential benefits of that permission. Google would argue here that there simply couldn't be a market for copyright permissions for the accumulation of data for a comprehensive book search engine because the costs of proactively clearing rights are simply far too high. The second limiting principle relates to the idea-expression distinction. As the reverse engineering cases aptly demonstrate, a copyright owner has no protectable interest in preventing the copying of unprotectable expression. Google would argue that although it is copying expressive works to build its library database, its use of these works is entirely non-expressive in the capture and processing phases. The works are not copied for their expressive content, but rather to create a vast catalog of metadata which enables the search engine to operate. The third limiting principle which is relevant here is that transformative uses do not usually have an effect on the market for or the value of the copyrighted work. Google would argue that its use is highly transformative because it provides an entirely new use for the original works and because it is transforming concrete text into abstract metadata. Even assuming that the court concluded that the scanning for inclusion in a book search database was fairly within the copyright owner's market, the court would still need to consider the implications of the opt-out mechanism Google has promised to comply with. If authors do have the right to determine whether their works become part of the book search engine, then the value of that right equates to the compensation they could demand in return for not withholding their works. In other words, for an individual book, the value of the right is determined by the contribution that particular book makes to the book search engine as a whole. Google is in a fairly strong position to argue that a low-cost opt-out measure would effectively negate any potential adverse market effect. After all, whether the system is opt-in or opt-out, the author should be able to realize the value of an individual work by offering to opt-in or offering not to opt-out. If the opt-out makes no difference on this construction, why would any copyright owner object? There are two principal reasons. First, it might be the case that opting out is not in fact low cost after all. The process might be difficult, time-consuming, or uncertain. Second, as the class action lawsuit demonstrates, an opt-in regime gives the copyright owner the power to object on behalf of all copyright owners, a power which can be used to extract rents far exceeding the value of the copyright owner's own individual contribution. In other words, an opt-in regime empowers copyright owners to act strategically to extract some of the surplus value of the joint enterprise contributed by authors who do consent, the value of public domain works, and the value of Google's considerable investment. While this might be a legitimate commercial strategy, it seems doubtful that any of the copyright owners' inability to extract rents beyond the value of their own contribution is a cognizable market harm under the fourth fair use factor. Who would have won the fair use argument? Fair use is a flexible doctrine, and the courts have shown a willingness in the past to use it adaptively, especially in new technology cases. It seems that Google had a number of strong arguments within the traditional four-factor fair use framework already discussed. It also seems that Google's argument becomes stronger if we assume that the ruling would be conditioned on the kind of low-cost opt-out mechanism for authors that Google has already offered to make available. No matter how strong we or Google might have perceived their case to have been, the fact remains that there are no certainties in litigation. Google was risking a substantial possibility of statutory damages. In addition, an adverse legal precedent in relation to book search could have undermined many of the favorable legal precedents Google relies on with respect to its core internet search business. In short, regardless of the strength of Google's fair use argument, there was a sound business case for settling with the plaintiff authors and publishers. I hope that this fair use analysis has been useful. In the next series of videos, I'll be analyzing the terms of the settlement agreement itself.